Picture this. A courtroom, the kind where the air feels heavy with the weight of years of conflict, where every word spoken could tip the scales of fortune. A high-stakes debt recovery case. The lawyers are locked in battle, using every tool in their arsenal. And then, mid-trial, the huddle.
Yeah.
Whispers give way to terms, hands are shaken, papers signed. A settlement, case closed. A moment of relief, a quiet end to the storm.
Or so it seems.
Exactly. But what if that seemingly safe harbor, that resolution reached by agreement, was actually the trigger for a whole new multi-million-dollar legal fight?
A fight that wouldn't just revisit the original dispute, but would target the lawyers themselves.
Right, questioning whether their advice in reaching that settlement was negligent, and if so, whether they could hide behind the shield of advocates' immunity.
It sounds like the opening scene of a legal thriller, doesn't it? But this is the very real, very dramatic story at the heart of the landmark Australian High Court case, Atwells v. Jackson Lalic Lawyers, Plenty Limited. This wasn't just about a debt that went bad. It became a defining battle over the crucial and sometimes controversial boundaries of professional protection for lawyers acting for clients in court matters.
Absolutely. This is far from a dry legal report. It's a gripping drama about what happens when a settlement unravels and a seemingly secure legal principle, advocates' immunity, faces a fundamental challenge.
And embedded within this story is a powerful cautionary tale, particularly for you if you're considering a career at the bar, or indeed if you're a solicitor who briefs counsel or advises clients on litigation.
Definitely. At its core, this deep dive is asking one pivotal question. When does a barrister's immunity from being sued for negligence end?
Yeah. Does that protection, designed primarily to safeguard the finality of judicial decisions, extend to advice giving out of court that leads a case to settle by agreement?
Even when that agreement is then formalized by a court order. That's the key, isn't it?
That's the nub of it.
So, our mission today is to pull back the curtain on this legal drama. We'll introduce you to the key players in the original debt battle, map out the procedural twists and turns that led to that fateful settlement and its collapse.
And then follow the subsequent legal fight through the courts against the lawyers themselves. We need to understand the arguments for and against the immunity shield. And most importantly, unpack what the High Court's final decision means as a lesson for the legal profession.
And we'll be doing all this strictly based on the material you've provided us.
Okay, let's set the stage for the initial conflict, the one that started it all and led to the settlement that became, well, the source of so much trouble.
Right. We need our cast list. The dramatis personae, part 1.
Absolutely. In one corner, the parties seeking to recover money, ANZ Bank. They were the plaintiff in the original proceedings, aiming to claw back a very significant debt.
Okay, the bank.
Ah.
And on the other side?
On the other side were the defendants, the ones being pursued for this debt. This group included a company that owed the initial funds. Now, by the time this story gets to the High Court, that company is in liquidation, so its role becomes slightly less direct.
Right.
Though its original debt is central. More immediately relevant are two individuals, Mr. Gregory Ian Atwells, who becomes the first appellant in the later case, and a Mrs. Lord. These individuals were involved not as the primary debtor, but as guarantors of the company's debt.
Ah, guarantors. That distinction sounds important.
It's critical. The difference between the company's debt and the guarantor's liability under their guarantee really comes into play later on.
And the sum at stake. We're talking big numbers here.
Oh, yes. Serious money. The bank was seeking almost $3.4 million specifically, $3,399,347.67 from the company. And those guarantors, Mr. Atwells and Mrs. Lord.
Wow. Nearly $3.4 million. And that figure, you said, is crucial.
Absolutely crucial, because it's the exact number that would eventually appear by consent in a court order. Remember that figure.
Got it. $3.4 million. Now, who were the lawyers involved back then in that first debt recovery fight?
Okay, so for ANZ Bank and their receivers, the Material Notes Council appeared, but their specific names aren't provided in our sources.
Right.
On the side of Mr. Atwells, Mrs. Lord, and the company, their instructing solicitors were Jackson Lalic Lawyers, Plenty Limited.
Okay, Jackson Lalic, they're the ones who later get sued.
They are indeed. They become the defendants in the negligence suit we're focusing on. Jackson Lalic, in turn, briefed senior counsel, a barrister, to appear on behalf of their clients at the trial.
And again, we don't have the name of that specific senior counsel.
No, the name isn't provided in our sources, but their actions and advice on that first day of trial are absolutely central to this whole story. Their role is pivotal.
Okay, So let's recap the procedural setup before the trial started. We've got ANZ Bank demanding nearly $3.4 million from a company and its guarantors. They couldn't sort it out, so it's listed for a full trial in the Supreme Court of New South Wales, set to be heard before Justice Rain. Everyone's gearing up for a big legal battle.
That's the picture. And the trial date arrives, June 15, 2010. The proceedings kick off in the Supreme Court.
And right here, on day one, we hit a really critical piece of information, something that seems, well, almost contradictory given where things ended up.
Yes. In their opening remarks to Justice Rain, counsel for ANZ Bank made a pretty significant acknowledgement.
What was that?
While the total debt owed by the company was indeed close to that $3.4 million figure, the bank clarified to the court that the amount owed specifically by the guarantors, Mr. Atwells and Mrs. Lord, under their guarantee was substantially less.
Really? How much less?
According to the sources, the bank's counsel certified that the amount due under the guarantee was $1.5 million plus interest and costs. The total they put on that was $1,856,182.28.
Okay, so hold on. The bank itself, in open court, says the guarantor's liability is around $1.86 million, not the full $3.4 million.
That's what the sources state, a very important distinction.
That is a key point. The party chasing the money acknowledges the guarantors owe about $1.86 million. And yet, what happened next?
Well, despite this being said on the first day of trial, in the evening of that same day, June 15th, 2010, the senior counsel briefed by Jackson Lalic Lawyers, remember, the lawyers for the debtors and guarantors engaged in settlement negotiations.
Even after the bank had flagged the lower figure for their clients.
Apparently so. And they reached an agreement. The terms were that Mr. Atwells and Ms. Lord would pay the bank the sum of $1,750,000.
$1.75 million.
Yes. And this amount was agreed to be inclusive of costs. They were given a deadline, too, until November 19th, 2010 to make this payment.
Okay, so on the face of it, $1.75 million. That seems, well, potentially quite good for the guarantors, doesn't it? It's even slightly less than the $1.86 million the bank had certified their liability to be.
It looks that way initially. $1.75 million versus $1.86 million. Seems like a reasonable outcome.
But this is where the story takes a dramatic turn, right? The devil is always in the detail, especially the procedural detail. How was this settlement agreement actually formalized?
Yes. This is the pivot point of the entire case. It wasn't just a private handshake or, a standard confidential deed of settlement tucked away in a file.
No? What happened?
The settlement was formalized and reflected in a formal order entered by the court on June 16th, 2010, the day after the agreement was struck.
A court order?
Yes. And this order had two very distinct sections sitting side by side, which is highly unusual and incredibly important here.
Okay, let's break down this court order. Section 1, what did it say?
Section 1 starts with the words, by consent, the court orders that. Pretty standard opening for a consent order.
Right.
But then it states that the court entered verdict and judgment for the ANZ Bank against Mr. Atwells, Mrs. Lord, and the company in the sum of $3,399,347.67.
Wait, what? The full amount?
Yes, you heard that right. By consent, their consent, the court formally ordered and entered judgment against Mr. Atwells and Mrs. Lord, among others, for the full amount the bank was originally claiming from the company, nearly $3.4 million.
The bank's own lawyer had just said their liability under the guarantee was only $1.86 million. How could they consent to a judgment nearly double that?
That is precisely the question that forms the core of the later negligence claim. It seems extraordinary. And this Section 1 also included other things, like orders for possession of land and water rights.
So Section 1 creates this official, enforceable court judgment debt of almost $3.4 million against the guarantors by their own consent, even though the bank itself had seemingly agreed their liability was much lower.
That's what the court order did, yes. It feels like signing up for a debt you don't actually owe, doesn't it?
It really does. Okay, so that's Section 1, the massive consent judgment. What about Section 2? You said there were two parts.
Right. Section 2 is where the actual settlement agreement gets recorded. This section is titled The Court Notes, the agreement between...
Notes, not orders.
An important distinction. This part of the order formally recorded the agreement reached between the bank and the defendants, including Mr. Atwells and Mrs. Lord. It stated that the bank would not enforce the $3.4 million judgment orders entered in Section 1, Orders 1 to 9.
Okay, so a promise not to chase the big debt.
provided that, and this is the crucial condition, Mr. Atwells and Mrs. Lord paid the agreed settlement sum of $1,750,000 by the November 19, 2010 deadline.
I think I see. Section 1 creates the huge official debt via a court order. Section 2 says, okay, we won't collect on that huge debt if you pay this smaller amount by this date.
That's a good way to put it. The $3.4 million judgment was officially on the books, binding, enforceable, unless the condition in Section 2 is met. It's like agreeing to have a mountain of debt formally put on your record, but getting a temporary pass on paying it. Conditional making a much smaller payment on time.
But what if they didn't make the smaller payment on time?
The default provision. Absolutely critical. Section 2 also contained this. The court order specifically noted that if Mr. Atwells and Mrs. Lord failed to comply with their obligations under the agreement, the key one being paying the $1.75 million by the deadline,
Yes.
the bank would be, and I quote from a source, at liberty to enforce orders 1 to 9 forthwith.
Forthwith. Immediately.
Immediately. The sources highlight that word. No grace period, no further negotiation noted. Just boom, the $3.4 million becomes due.
Wow. So that settlement agreement meant to end the dispute actually turned that massive $3.4 million consent judgment into a ticking time bomb, primed to explode if they missed that single $1.75 million payment.
Precisely. Which leads us, almost inevitably it feels, to the downward spiral, the procedural summary of what happened after that very intricate consent order was made.
Did they make the payment?
As the sources state, Mr. Atwells and Ms. Lord failed to pay the $1,750,000 by the deadline of November 19th, 2010.
They missed it.
They missed it.
And because they defaulted on that specific condition, noted by the court in Section 2 of the order, the safety catch was released.
Exactly. The ANZ Bank and the receivers were now, by the very terms of the consent order the parties had agreed to, free to enforce the full consent judgment of $3,399,347.67.
So suddenly, they're facing a judgment debt over $1.6 million larger than the amount they thought they'd settled for, and way larger than the amount the bank's own lawyer had said they owed under the guarantee.
That's the crushing consequence of how that default clause operated on the pre-existing consent judgment in Section 1. It wasn't a penalty for non-payment of $75's MS. It was the activation of the $3.4 million debt.
Did they try to challenge this? It seems incredibly harsh.
They did. On February 11th, 2011, an application was made to the court to set aside the $3.4 million judgment and the related order.
On what grounds?
The argument raised was that the consequence of defaulting on the $1.75 million payment, triggering liability for the full $3.4 million, amounted to an unenforceable penalty, essentially arguing it was a punishment grossly disproportionate to the breach, which was failing to pay $1.75 million.
That seems like a plausible argument, given the huge difference in the numbers. Did it work?
It did not. Justice Pembroke heard the application and dismissed it.
Dismissed.
Yes. The $3.4 million judgment against Mr. Atwells and Mrs. Lord remained in force. The trap sprung by the default on the payment couldn't be reset by arguing the consequence was an unenforceable penalty. The consent judgment stood.
So the original debt battle is finally over, but it ends with the guarantors liable for the full $3.4 million, all because of that default clause in the settlement order.
That's the outcome of the first part of the story.
And this, then, is where the new legal drama begins. The fight shifts from the bank versus the guarantors to the clients versus their former lawyers.
Exactly. This brings us to the dramatis personae, Part 2, the players in the negligence claim.
Who are the plaintiffs this time?
The plaintiffs are the Atwells. First, Mr. Gregory Ian Atwells, the original guarantor we've been talking about. He's now the first appellant in the high court case, suing his former solicitors.
Okay.
And second, Mr. Noel Bruce Atwells, the second appellant. The sources note something interesting here. The cause of action belonging to the company, which was now in liquidation,
Right.
was assigned to Mr. Noel Bruce Atwells by the company's trustee in bankruptcy. So effectively, the parties who were ultimately hit with that large judgment debt are now suing the lawyers who advised them on the settlement that led directly to it.
And the defendants, the ones in the firing line this time?
Jackson Lalic Lawyers, Spinal Limited, the solicitors who acted for the Atwells and Mrs. Lord in the original proceedings, and crucially, the ones who briefed the senior counsel who negotiated that fateful settlement.
Right. Now, this negligence case went all the way to the high court. Who are the lawyers involved in this battle? It must have been quite the lineup.
It was. For the Atwells, pursuing their negligence claim, the instructing solicitors were Elsie Muraniti and Associates, acting as agent for Gary White's lawyers. At the high court, their counsel team was quite formidable. led by Mr. G.O.L. Reynolds, SC, and including Ms. R.C.A. Higgins, Mr. R.A. Yezierski, and Mr. D.W. Robertson.
A strong team indeed. And who was defending Jackson Lalic Lawyers against these serious allegations?
Their instructing solicitors were Spark Helmore Lawyers. In the High Court, their counsel was led by Mr. A.S. Bell, SC, who was assisted by Mr. P.D. Hertzfeld.
Another heavyweight team.
Absolutely. And interestingly, because this case had such potentially huge implications for the entire legal profession in Australia,
Yes.
the Law Society of New South Wales sought and was granted leave to appear as an amicus curiae.
A friend of the court.
Exactly. Their role wasn't to take sides, but to assist the High Court by providing submissions on the broader policy considerations. Things like, the potential impacts of the decision on legal practice generally, given how important advocates' immunity is perceived to be.
Who represented the Law Society?
Their instructing solicitors were Allen's, a major firm, and their High Court barristers were Mr. R.P.L. Lancaster, SC, and Mr. N.J. Owens.
So we have the stage set for the negligence battle. The clients versus their former lawyers with top legal teams on both sides, and the Law Society watching closely. What were the specific failures, the alleged acts of negligence, that the Atwells were pinning on Jackson Lalic Lawyers?
Well, on August 16, 2012, the Atwells filed their amended statement of claim. Their central argument was, unsurprisingly, the Jackson Lalic Lawyers were negligent in the advice they provided during the original proceedings, specifically concerning that settlement agreement and the consent order that followed.
Right.
The sources list several specific particulars of negligence, which really get to the heart of what they claim went wrong.
Let's break those down. What were the key allegations?
Okay, first, they alleged that Jackson Lalic Lawyers were negligent in advising Mr. Atwells to consent to that judgment, sum the full $3.4 million. They argued this sum, and I quote, materially exceeded any possible liability he actually had as a guarantor, especially given the bank's own statement in court that his guarantee liability was only around $1.86 million.
So, allegation one, you advised us to agree to liability for almost double what the other side said we owed under the guarantee. That seems like a pretty basic error, if true.
It's a stark allegation. Second, they alleged negligence in advising Mr. Atwells that defaulting on the $1.75 million payment would not make any difference to the effect of the $3.4 million judgment.
Wow. Okay, that's the core issue with the default clause, isn't it? The claim is the lawyers told them essentially, don't worry, if you miss the $1.75 payment, it won't trigger the big one.
That's exactly the implication. It suggests the clients might have believed, based on that alleged advice, that missing the payment meant they'd still only be on the hook for something related to the $1.75 million, not the full crippling $3.4 million.
That's a huge alleged misrepresentation of the risk.
Thirdly, and closely related, the Atwells alleged a failure to advise them on the correct effect of the consent order itself, and particularly the operation and consequences of that critical default clause.
So, not just giving wrong advice about the outcome of default, but a more fundamental failure to actually explain what the legal document, the court order they were consenting to, actually did and how it worked.
Precisely, a failure of explanation. Fourth, they alleged a failure to advise Mr. Atwells to simply refuse to consent to the orders as proposed by the bank. Meaning, given the potential catastrophic downside of that default clause triggering the huge judgment, the Atwells argued the lawyers should have advised them not to agree to that specific structure of order at all, perhaps negotiate a different settlement mechanism.
Because if they hadn't consented to Section 1, the $3.04 judgment, then the default condition in Section 2 wouldn't have had that specific devastating consequence of activating it.
That's the logic underpinning that part of the claim. And finally, they put it all together, alleging that as a direct result of these various negligent actions and advice, Jackson Lalic Lawyers caused Mr. Atwells to incur a liability, that $3.4 million judgment, which, based on the bank's own figures, he did not actually owe.
And the damages they sought.
They were seeking significant damages to cover that loss, plus interest, plus costs, a multi-million-dollar claim flowing directly from that settlement advice.
Okay, faced with these very serious allegations, potentially firm-ending allegations, how did Jackson Lalic Lawyers defend themselves? What was their shield?
Their primary and really their core defense was to invoke the doctrine of advocates' immunity.
Advocates' immunity.
Yes. They argued that even if, and this is just for the sake of argument, not an admission, their advice regarding the settlement was negligent, they were shielded from liability by this fundamental legal principle. It was a complete defense, they argued.
Right. Let's take a moment to really understand this concept. Advocates' immunity. What is it, as explained in the sources, and why does the law provide this protection to lawyers? It seems counterintuitive that a professional could be immune from negligence.
It does seem that way on the surface, but it's a well-established doctrine in common law, with roots going back centuries in England. It's been recognized and developed by the High Court of Australia in key cases, particularly Gianarelli v. Wraith back in 1988, and Dorda Ikanaiki v. Victoria Legal Aid in 2005.
Okay, and what does it do?
In essence, it protects advocates, that means barristers, and also solicitors when they are performing advocacy functions or work closely related to it from being sued for negligence.
Negligence in doing what exactly? Just arguing in court?
Not just arguing in court, although that's covered. The immunity covers their actions in the courtroom while conducting a trial, but also work done out of court, provided that out-of-court work has what the courts call an intimate connection with the conduct of a case in court.
An intimate connection. That sounds like a key phrase. What does it mean?
It's crucial. It's not just any work related to litigation. The High Court has described it as work so intimately connected with the conduct of the case in court as to be a preliminary decision affecting the way that cause is to be conducted when it comes to a hearing. So it has to have a direct functional link to the in-court proceedings.
Okay, so it covers courtroom work and closely related out-of-court work. But why? What's the fundamental reason the High Court says this immunity exists? Is it just to protect lawyers?
No, the stated rationale isn't primarily about protecting lawyers themselves, although that's an effect. The primary driver, the public policy justification, repeatedly emphasized by the High Court, especially in Dorta, is the principle of finality.
Finality, meaning once a court case is over, it's over.
Pretty much. It's a cornerstone of our judicial system. The idea is that judicial controversies, once they've been heard and resolved by a court, should be considered finally settled and shouldn't be reopened indirectly.
How would a negligence suit reopen things?
Well, the concern is that if you allow a client to sue their lawyer for negligence relating to a past case, the client would inevitably have to argue in the negligence claim that, but for the lawyer's mistake, the original court outcome would have been different. Maybe they would have won or got a better result.
I see. So the second court hearing the negligence case would have to effectively rejudge the first case to see if the outcome would have been different.
Exactly. It becomes what the courts call a collateral attack on the original judicial decision. It undermines the finality and authority of that first decision. The High Court in Dorta stressed the immunity protects the finality of judicial determinations and the integrity of the judicial process itself.
So the immunity exists mainly to protect the court system and the authority of its decisions, rather than the lawyers per se.
That's the core public policy justification relied upon by the High Court. It's about the proper quelling of controversies by the judicial arm of government. Allowing these negligence claims could lead to conflicting findings between courts and erode public confidence in the original judicial decision.
Okay, I understand the principle of finality now. So how did Jackson Lalic Lawyers argue that this immunity shield applied specifically to them in the Atwell's case, given the claim was about advice leading to a settlement?
Their argument, which was later accepted by the Court of Appeal, was that their advice to settle the case was intimately connected to the conduct of the case in court. Why? Because it directly led to the termination of that litigation. It brought the court proceedings to an end.
So ending the case, conduct of the case.
That was their contention. And crucially, they pointed out that the settlement wasn't just a private deal, it was formalized and recorded in a consent order of the court.
Ah, the court order again.
Yes. They argued that allowing the Atwell's negligence suit, which essentially claimed the $3.4 million consent judgment should not have been given, or that the advice leading to it was flawed, would inevitably involve re-examining the original proceedings. It would require the negligence court to decide if the outcome should have been different, thereby offending that crucial finality principle, just as much as challenging the outcome of a fully contested trial would.
So their position was, our advice led directly to a court order that ended the case. Suing us over that advice undermines the finality of that court order and improperly reopens the original dispute. Therefore, we're immune.
That was the essence of their defense, a powerful argument based on established high court authority. And this defense had to be tested.
Where did he go first?
It went to the Supreme Court of New South Wales. But before a full trial on negligence, Jackson Lalic Lawyers took a specific procedural step. They applied for what's called a separate question determination.
A separate question. What's that?
It's a mechanism under the court rules the Uniform Civil Procedure Rules, Rule 28.2 to be specific. It allows a court, if it thinks it's appropriate, to decide a specific question of law or fact separately from, and usually before, the rest of the proceedings.
Why would they do that here?
Well, Jackson Lalic wanted to resolve the immunity defense up front, because if the court found that advocates' immunity did apply, then the entire negligence case against them would fail, regardless of whether they were actually negligent or what damage was caused.
Ah, I see. It's a potential knockout blow. If immunity applies, game over for the plaintiffs. Saves everyone a lot of time and money, potentially.
Precisely. It avoids a possibly long and expensive trial on the detailed facts of the negligence and the calculation of damages if the immunity provides a complete shield. The Atwells actually consented to having this separate question determined first.
And how did they argue it? Did Jackson Lalic have to admit negligence just for this argument?
No, and this is important procedurally. For the purpose of arguing only the immunity question, the parties agreed on a specific statement of facts. And crucially, this statement of facts assumed, solely for the purpose of the immunity argument, that the Atwells' allegations of negligence were true.
Just assumed.
Yes, but without Jackson Lalic actually admitting they were true for the main trial, should it proceed. It's a common procedural device. It allows the court to consider the immunity point based on the plaintiff's best possible case regarding the alleged negligence.
Okay, so the Supreme Court, Justice Harrison, heard arguments on this separate question. Assuming the advice was negligent, as claimed, does advocate's immunity protect Jackson Lalic? What did Justice Harrison decide?
Well, interestingly, Justice Harrison heard the arguments, but actually declined to give a definitive answer to the separate question at that stage.
Declined to answer.
Why? The sources don't detail his exact reasons for declining, but sometimes judges feel it's better decided with the full facts or that it's too complex for a preliminary determination. However, the sources do say that his preliminary conclusion leaned towards immunity.
So, no formal ruling, but an indication he thought immunity likely applied.
That seems to be the takeaway. His preliminary view is that the losses claimed by the Atwells were probably within the scope of advocates' immunity, a tentative nod towards Jackson Lalic.
Not the knockout blow they wanted, but perhaps encouraging for them. What happened next? Did they appeal?
They did. Jackson Lalic Lawyers appealed Justice Harrison's decision not to answer the question to the Court of Appeal of New South Wales.
And who heard it there?
The Court of Appeal bench comprised Chief Justice Bathurst, Justice Meagher, and Justice Ward. They first granted Jackson Lalic leave to appeal.
And did they agree with Justice Harrison?
No, they held that Justice Harrison had actually erred by not providing a definitive answer to the separate question. They felt it was capable of being answered.
So did the Court of Appeal then answer it themselves?
They did. They proceeded to answer the question definitively.
And their answer was?
They ruled squarely in favor of Jackson Lalic Lawyers.
Really? So immunity applied?
Yes. The Court of Appeal held that advocates' immunity was a complete answer to the Atwells' negligence claim. Full stop.
Wow. So the immunity shield held strong in the Court of Appeal.
Right.
What was their reasoning? Did they adopt Jackson Lalic's broad view of intimate connection?
Essentially, yes. The Court of Appeal found that the advice given by the senior counsel regarding the settlement fell within categories of work done out of court affecting the conduct of the case in court. They concluded that the alleged breach of duty happened when advising on the settlement, and because this advice led to the proceedings being settled, it was therefore intimately connected with their conduct.
So advice that ends the case via settlement, intimately connected with the conduct of the case, immune.
That was the Court of Appeal's logic. They explicitly stated that advocates' immunity was a complete answer to the Atwells' claim. For a moment there, it looked like the story was over and the lawyers were fully protected by the immunity.
But the Atwells clearly didn't accept that. They took it higher.
They weren't finished yet. This brings us to the final, highest stakes battle, the appeal to the High Court of Australia.
The highest court in the land.
Indeed. The Atwells sought and were granted special leave to appeal the Court of Appeal's decision. The case was heard by a full bench of 7 High Court justices: Chief Justice French, Justice Kiefel, Justice Bell, Justice Gagler, Justice Keene, Justice Nettle, and Justice Gordon.
The full bench.
Yeah.
And the Law Society of NSW was there too, as amicus.
Yes, they were granted leave to appear and make submissions, given the potential ramifications for the whole profession.
So what were the precise legal questions, the key issues that the Atwells put before the High Court? What were they asking the justices to decide?
The sources clearly lay out three main issues the Atwells raised on appeal. They were really attacking the Court of Appeals decision from multiple angles.
Okay, what was the first issue?
First, they argued that the Court of Appeal had either applied the wrong test for advocates' immunity altogether, or if the test itself was correct, they had misapplied it to the specific facts of this case, particularly the settlement context.
So, challenging the very foundation of the Court of Appeals reasoning. Either the rule they used was wrong, or they used the right rule wrongly.
Exactly. Second, and this is really getting to the heart of the distinction they wanted to make, they argued the Court of Appeal erred in holding that immunity applied to negligently advised settlements, where the subsequent negligence claim did not involve a collateral challenge to a judicial determination on the merits.
Ah, the on the merits point again. This is the argument that a consent order based on a deal is different, for immunity purposes, from a judgment where the judge actually decided the case after hearing evidence and arguments.
Precisely that. They were saying their claim wasn't attacking a judge's decision on who was right or wrong, but the advice that led them to agree to the terms embodied in the consent order.
A crucial distinction. And the third issue.
The third issue was the broadest and potentially most radical. The Atwells asked the High Court to fundamentally reconsider its own previous landmark decisions on advocates' immunity, specifically Generelli and Dorta.
Reconsider. Meaning what?
Meaning, they invited the High Court to potentially narrow the scope of the immunity as defined in those cases, or even to go further and overrule those decisions entirely, effectively abolishing advocates' immunity in Australia.
Wow. So they were saying, either interpret the existing immunity rule so it doesn't cover our settlement situation, or if the rule does cover it as it stands, then get rid of the rule altogether because it's wrong. That's a bold move challenging settled high court precedent.
It certainly was a very significant challenge to established law, and this really set the stage for the detailed, high-level legal arguments presented before the 7 high court justices. It was a real intellectual battle.
Let's dive into those arguments. What was the core of the Atwells case before the High Court presented by Mr. Reynolds SC? How did they argue immunity shouldn't apply here?
Their central argument, bidding on that second issue, was that advocates' immunity, when you properly understand the reasoning in Generelli and Dorta, only applies when the advocate's work, whether it's in court or out of court, is so intimately connected with the court proceedings that it directly affects the judicial determination of the case.
Judicial determination.
Yes, and they really emphasize that this requires the controversy to be quelled by the exercise of judicial power based on the court actually deciding the merits of the dispute between the parties.
So immunity kicks in only when the judge makes a decision that resolves the case based on the law and facts.
That was their submission. They argued vehemently that a settlement reached purely by agreement between the parties is fundamentally different, even if that agreement is later noted by the court or formalized into a consent order.
Why different?
Because, they argued, the resolution stems from a private contract, a deal struck between the parties, not from the court applying its judicial power to the facts and the law to determine the parties' underlying rights and liabilities. The court is essentially ratifying the parties' own agreement, not making its own decision on the merit.
It's the parties deciding to stop fighting on agreed terms, rather than the court declaring a winner based on the fight itself.
That's the distinction they were drawing. And because of this fundamental difference, they argued, suing a lawyer for negligent advice that leads to such a settlement agreement or consent order does not constitute a collateral attack on a judicial determination on the merits.
So it doesn't trigger the finality concerns that justify the immunity.
Exactly. They argued it doesn't offend the finality principle in the specific sense required by Dorta. They stressed they weren't trying to get the High Court to say the original consent order was invalid as a court order. It still stands. They were saying their lawyer's bad advice caused them to agree to the terms that became that order, resulting in loss.
Did they use the previous High Court cases to support this distinction?
Yes, they tried to distinguish Generelli and Dorta, pointing out that those cases involved challenges to work that did relate directly to judicial decisions on the merits, things like how a lawyer conducted a trial which led to a conviction or losing the case. They even cited Lord Diplock in an old UK case, Saif, which hinted at a distinction for court orders made otherwise than on the merits.
Their point being, suing over bad settlement advice doesn't force a court to second-guess a previous judge's decision on the evidence. It asks whether the lawyer gave competent advice about entering into the settlement contract.
Precisely. And they also pushed the broader argument, the third issue, that advocates' immunity is just an anomaly in modern professional negligence law.
How so?
They argued it protects lawyers in a way other professionals like doctors or engineers aren't protected for their advice or actions. They pointed to the UK and New Zealand, other similar common law countries, which had abolished advocates' immunity years ago, reportedly without the sky falling in or the justice system collapsing as some had predicted.
Suggesting Australia could do the same.
Yes, or at least significantly confine the immunity. They also suggested the current intimate connection test was proving unclear and difficult for lower courts to apply consistently, especially around settlements.
Okay, so the Atwell's core position. Immunity is tied strictly to judicial decisions on the merits. Settlement agreements fall outside that, so immunity doesn't apply here. And maybe we should get rid of the immunity anyway because it's an outdated anomaly.
That summarizes their key arguments well.
Now let's hear the counterarguments. What did Jackson Lalic Lawyers, through Mr. Bell SC, argue in defense of the immunity applying to them?
They came back strongly, defending the Court of Appeals reasoning and the broader scope of the immunity. They argued forcefully that the intimate connection test, as established in Dorda, does extend to advice that leads to the termination of litigation, and that absolutely includes settlement by agreement, especially when formalized by a court order like this one.
How did they justify that connection?
They contended that advising on settlement isn't some peripheral activity. It's an inherent and often critical part of conducting a case. It directly affects the case's conduct in court by bringing it to a close. Ending the case is part of conducting it, in their view.
So, our work ended the case that was properly before the court, that's intimately connected, full stop.
Pretty much. And they presented a broader interpretation of the finality principle than the Atwells did. Mr. Bell SC argued that finality isn't just about protecting judgments reached on the merits after a contested trial. It's about protecting the final quelling of the controversy by the exercise of judicial power, regardless of the exact form that takes.
So a consent order still counts as judicial power quelling the controversy?
Yes. They argued a consent order, even if based on agreement, is still a formal court order. It represents an exercise of judicial power that merges the parties' prior rights and obligations into a final, binding, enforceable judgment. They reference the legal principle that a judgment extinguishes the underlying cause of action.
How did they apply that to the default clause in Atwell's?
They argued that the failure to pay the $1.75 million didn't create some new right for the bank to claim $3.4 million. It simply allowed the enforcement of the $3.4 million judgment that already existed by virtue of the court's consent order made back in June 2010. This, they argued, was a consequence flowing from a lawful result lawfully reached, the consent order itself.
So they saw the consent order as the definitive exercise of judicial power that finalized the dispute, and therefore attacking the advice that led to that order was an attack on finality, triggering the immunity.
Exactly. And they brought back the concern about skewed litigation if immunity didn't apply here.
What was that concern again?
They argued that allowing negligence suits based on settlement advice would often force the court hearing the negligence claim into difficult territory. It would have to try and second-guess the lawyer's judgment call about how the original trial likely would have unfolded if it hadn't settled. This might involve speculating about how the original judge would have decided things, maybe even looking into that judge's known tendencies or disposition, or how they handled the case up to that point. This, they argued, leads to awkward, hypothetical, and ultimately skewed litigation that is problematic for the administration of justice.
It's hard for Court B to say definitively what Judge A would have done years earlier if the case had run.
Right. It involves counterfactuals layered on counterfactuals. They also argued that trying to draw a clear line for immunity based on the degree of judicial involvement in a settlement, distinguishing between a simple notice of discontinuance versus a consent order versus a settlement reached in a judge-assisted mediation would be practically unworkable and lead to endless legal uncertainty. Where do you draw that line?
A fair point about practicalities.
Yeah.
And what about the Atwell's call to abolish the immunity altogether?
Jackson Lalic strongly resisted that. They argued there had been no fundamental change in the Australian legal or social landscape since the High Court affirmed the immunity in Gianarelli and Dorda that would justify overturning those major precedents. They specifically noted that, unlike in the UK and New Zealand where legislatures stepped in, the Australian Parliament had not legislated to remove or limit advocates' immunity, implying tacit legislative acceptance of the High Court's position.
Okay, so Jackson Lalic's arguments boil down to advice leading to a settlement finalized by a court order is intimately connected to court conduct. Suing over it does offend finality and leads to problematic litigation. Drawing lines based on judicial involvement is too hard, and there's no good reason to abolish the established immunity.
That captures their main points.
Now, what perspective did the Law Society of New South Wales bring to the table as the amicus curiae, the friend of the court representing the broader profession's interest?
The Law Society, through Mr. Lancaster SC, generally supported Jackson Lalic's position that the immunity should apply to advice leading to settlement. Their arguments really focused on the practical realities of legal practice and the often blurred lines between formal court proceedings and settlement processes.
How did they frame that relationship between settlement and court process?
They emphasized the formal and often very close connection. They pointed out that settlement negotiations aren't always just happening in the background. Things like mandatory pre-litigation steps, court-ordered mediations, sometimes involving judicial officers or court-appointed mediators who might have their own immunity, and rules about making formal settlement offers, like Calderbank offers or offers of compromise, are frequently brought within the formal structures and rules of court proceedings.
So settlement isn't just a side deal. It's often deeply integrated into the court's own processes for managing and resolving cases.
That was their point. Lawyers have duties, sometimes imposed by the court rules or practice notes, to genuinely attempt settlement. They argued that advice and negotiations about settlement are therefore not peripheral to the case. They are often an integral part of its management and disposition under the court's supervision.
Making the case that settlement advice is therefore part of the conduct of the case, protected by immunity.
Yes. They also stress the potentially significant and disruptive implications for legal practitioners across all areas of law if the immunity were narrowed in the way the Atwells proposed.
What kind of implications?
Concerns about uncertainty, basically. If the High Court changed the rules retrospectively, it could potentially expose lawyers to negligence claims for conduct and advice regarding past settlements that they had reasonably believed, based on the law as it stood, were covered by immunity. This could lead to a flood of litigation and increased professional indemnity insurance costs, impacting the profession broadly.
And did they have a view on the nature of consent orders specifically?
They did. They supported Jackson Lalic's view, arguing that court orders, even when made by consent, still involve an exercise of public judicial function. The court isn't just a rubber stamp. It has to be satisfied that the order it's making is within its power and is appropriate in the circumstances, even if it doesn't delve into the merits of the original dispute. This judicial involvement, they argue, distinguishes consent orders from purely private contracts and reinforces the idea that they involve an exercise of judicial power, linking them back to the rationale for immunity.
Okay. So the Law Society's position was essentially settlement advice leading to court orders is an integral part of managing litigation within the court system. Changing the rules now would be disruptive for the whole profession, and therefore this type of advice should remain within the scope of advocates' immunity.
That effectively summarizes their contribution. So you had these powerful arguments presented on all sides to the 7 justices of the High Court.
A complex legal debate with huge implications. The court then retired to consider its decision. What was the final outcome? Who won the appeal?
After deliberation, the High Court delivered its judgment in Atwells v. Jackson Lalic Lawyers, Secondly Limited. And the final ruling was, the High Court allowed the Atwells appeal.
They allowed the appeal, so they sided with the Atwells.
Yes, they sided with the Atwells on the crucial question of the scope of the immunity regarding settlements. The court held, definitively, that the advocate's immunity does not extend to negligent advice that leads to the settlement of a case by agreement between the parties.
Wow. Even if that agreement is reflected in consent orders made by the court.
Even then, the High Court was clear. Immunity does not cover negligent advice leading to a settlement agreement, regardless of whether that agreement is subsequently reflected in consent orders or merely noted by the court.
The immunity shield does not cover negligent advice on settling a case, even with a court order involved. That is a huge clarification, a fundamental boundary drawn. What was the High Court's reasoning for reaching this significant conclusion, overturning the Court of Appeal?
The High Court's reasoning went right back to first principles, back to the core justification for the immunity itself, that principle of finality and certainty of judicial determinations.
Oh,
They reaffirmed that the immunity's purpose is to protect the outcome when a controversy is resolved by the exercise of judicial power, ensuring that outcome isn't challenged collaterally through a negligence suit against the lawyer.
so protecting the court's own decision-making process on the merits of the case remains central.
Absolutely central. And building on that, they refined the understanding of that key phrase, intimate connection. The court stated that the required intimate connection for immunity to apply is specifically a functional connection between the advocate's work and the court's determination of the case's outcome by judicial decision.
A functional connection to the court's decision. That sounds like the critical distinction they drew.
It was. This is how they applied that distinction to settlements, even those formalized by consent orders.
How do they make that distinction work for settlements?
The court drew a very clear line. They said, essentially, while advice to settle is obviously connected to the litigation process in a general sense, it stopped the case. After all, it doesn't satisfy the specific requirement of an intimate connection to a judicial determination on the merits.
Why not?
Because, the High Court reasoned, a settlement, even one put into a consent order, represents a resolution arrived at primarily by the agreement of the parties themselves. It's not the result of the court actively determining the underlying rights and liabilities through the exercise of its judicial power after considering the evidence and arguments.
So even though the judge makes the consent order, the actual substance of the resolution, the terms, the outcome comes from the parties' deal, not from the judge independently deciding who was right or wrong on the original issues.
Precisely. The High Court acknowledged that the court's role in making consent orders or noting settlement agreements is certainly important and involves an exercise of public function. But, they reasoned, this role doesn't typically involve the court scrutinizing or determining the merits of the underlying dispute in the same way it would in a contested hearing leading to a judgment. The court essentially relies on the parties' consent and agreement.
So putting it simply, a negligence claim saying, my lawyer gave me bad advice which made me agree to a terrible settlement deal, is fundamentally different from a claim saying, my lawyer's poor performance in court caused the judge to rule against me.
Fundamentally different, according to the High Court's analysis in Atwell's. A negligence claim challenging advice that led to a settlement by agreement does not, in their view, involve a collateral challenge to a judicial determination on the merits of the original case. Because the claim doesn't deny the legal validity of the consent order itself, the order still stands as a court order. Instead, the claim argues that the lawyer's negligent advice caused the client to enter into the disadvantageous agreement that the order merely reflects. It's a challenge to the advice leading to the agreement, not the court's act in recording it.
It really sounds like the High Court felt the Court of Appeal and Jackson Lalic's arguments had stretched that concept of intimately connected too far, focusing too much on the end result, the case ending, rather than the mechanism of resolution, party agreement versus judicial decision on merits.
That's a very good summary of the High Court's core reasoning. The connection must be intimate specifically to the mechanism of judicial determination on the merits.
Did the High Court take up the invitation to abolish immunity altogether?
No, they declined that invitation. They were quite clear that they were not overruling Gianarelli or Dorder. They expressly upheld the principle of finality concerning judicial determinations made after a hearing on the merits. The core immunity remains intact for work intimately connected to that process.
So the shield wasn't removed entirely.
Not at all. But by excluding advice that leads to settlement by agreement from its protection, they significantly clarified and effectively narrowed the practical boundary of where that immunity applies. They drew a line in the sand.
Okay, so the shield remains for trial work and closely related preparation, but it definitely does not cover negligent advice about whether to settle or the terms of a settlement agreement, even if a consent order follows. What does this decision mean in practical terms? What are the real-world implications for barristers and solicitors advising clients in Australia today?
Well, the most immediate and significant implication is a clear and substantial narrowing of the practical scope of the advocate's immunity shield in Australia, particularly concerning settlements.
Which is a huge part of legal practice.
Exactly. Barristers and solicitors who engage in advocacy-related work, or crucially provide advice on settlement strategy and terms, are now potentially liable for negligent advice given out of court that results in a client entering into a settlement agreement. The immunity won't protect them from such claims.
And this liability covers advice about the settlement terms themselves and their potential consequences, like that default clause.
Absolutely. That's critical. It includes advice on whether to settle at all, the fairness or adequacy of the settlement amount, And, very importantly, advice explaining the precise legal effect and consequences of the specific settlement terms themselves. Especially complex or risky provisions like the default clause we saw trigger the disaster in the Atwell's case. Even if that settlement is ultimately formalized by court orders or noted by the court, the advice leading to it is now fair game for a negligence claim.
So this definitely means increased accountability for lawyers when it comes to the settlement advice they give.
It certainly does. Clients who believe they've suffered financial loss because their lawyer gave them negligent advice about settling their case advice that led them to accept, say, disadvantageous terms or misunderstand the risks involved or agree to something they shouldn't have, are now much more likely to have a viable claim against that lawyer. The immunity defense is off the table for that specific type of advice.
And that distinction the High Court drew between a resolution based on the court deciding the case on its merits versus one based on the parties agreeing, that's the absolute key nuance lawyers must now grasp.
It is absolutely fundamental. Every lawyer involved in litigation needs to be acutely aware of this distinction in their day-to-day practice. They can no longer operate under the assumption that any work connected to ending litigation via a settlement agreement will automatically be immune from challenge just because it relates to a court case.
No more blanket assumptions.
No. The immunity is now definitively tied much more tightly to the process of the court's own decision-making on the merits of the case. Advice concerning the agreement itself, its negotiation, explaining its terms, advising on its consequences, falls outside this core protected area.
Okay, let's try and distill this into concrete lessons. What's the cautionary tale here for aspiring barristers and solicitors, and indeed for those already practicing? What should lawyers take away from the whole Atwell's saga?
Right, the practical takeaways. First, and perhaps most obviously, extreme due diligence and precision regarding settlement terms are more critical than ever before. Meaning lawyers need to exercise extraordinary care when advising clients on settlement terms, particularly with complex clauses, any future obligations, or potentially punitive default provisions like the one in Atwell's. They must fully understand the potential implications of every single clause they advise their client to accept. And importantly, they need to ensure the terms align with the client's actual known position, and remembering the bank's own certified lower guarantee amount in Atwell's makes the consent to the higher figures seem, well, questionable without very clear advice.
So don't just act as a facilitator to get a deal done. You need to scrutinize the terms of the settlement agreement with the same rigor you'd apply to any major contract your client is signing, especially one born out of litigation.
Exactly. Second lesson. Crystal clear and comprehensive communication with the client is absolutely non-negotiable.
You mean explaining the deal properly?
Yes, and more. Lawyers must ensure their clients fully understand the precise legal effect and all potential consequences of the settlement terms they're agreeing to. This includes explaining the difference between, say, a private deed of settlement versus a formal court judgment, even one made by consent, and meticulously explaining the exact triggers and outcomes of any default provisions. The entire Atwell's negligence claim was essentially built on the allegation that the clients weren't properly advised about what defaulting on the $1.75 million payment would really mean.
And documenting that advice is probably crucial too.
Absolutely crucial. Having detailed file notes, maybe even written advice confirming the key points and risks, is essential for risk management. Make sure the client doesn't just nod along, but genuinely comprehends the deal, the risks, and what could happen if things go wrong.
Good point. What's the third takeaway?
Third, lawyers must know the precise boundary of their immunity. The High Court in Atwell's has made it crystal clear. Advocate's immunity is not some kind of blanket shield covering everything a lawyer does in connection with litigation. It is specifically and functionally linked to work that has an intimate connection to the court's determination of the case on its merits. Advice on negotiating and entering into settlement agreements falls outside this protection. Lawyers need to understand which parts of their work are likely immune and which are not.
So don't just assume you're covered because you're acting in a court case. Settlement advice is now clearly outside the fort.
That's a good way to put it. And finally, flowing from all this, the fourth takeaway is the need for serious risk management review by lawyers and law firms. Practices really need to reassess their procedures and protocols for advising on settlements in light of Atwell's. They need to ensure their processes meet the now clarified standard of care, recognizing the increased potential liability in this area. This might involve things like internal checklists for settlement advice, perhaps requiring a second partner review for complex settlements, and definitely mandating meticulous file notes that detail the advice given, the risks explained, and confirmation of the client's understanding and instructions. The potential exposure for getting settlement advice wrong has undeniably increased.
It sounds like it forces lawyers into a difficult balancing act, doesn't it? On one hand, settlement is generally encouraged. It saves costs, reduces court backlogs, gives parties control. On the other hand, advising on the complex terms of that settlement now carries significantly more personal risk for the lawyer.
It absolutely does create that tension. The Atwell's case really represents the High Court grappling with these competing public policy considerations. The need to maintain the finality and integrity of the judicial process versus the public interest in holding professionals accountable for negligence and ensuring clients have recourse when bad advice causes tangible harm.
And the High Court drew the line where?
They drew the line by preserving the immunity for work directly tied to the court's own decisions on the merits, but decisively opening up accountability for negligent advice that leads a client into a detrimental agreement, even when that agreement gets the court stamp of approval via a consent order.
So what began as a high-stakes debt recovery case took that dramatic turn with a fateful, complex settlement agreement formalized by a consent order, spiraled into a multi-million-dollar negligence claim against the lawyers involved, and culminated in this landmark High Court decision that fundamentally clarified and narrowed the limits of advocates' immunity in Australia, specifically around settlement advice.
It's a really compelling illustration of how seemingly small procedural details and the quality of legal advice can have absolutely profound financial and legal consequences.
And it stands as a powerful reminder, a real cautionary tale, that a lawyer's duty of care in guiding a client through the complexities of settlement is just as critical and now arguably more exposed to negligence claims than their performance during a trial itself.
It's a vital lesson from Atwell's. Advising on settlement demands immense care, absolute precision, and crystal clear communication. The shield of immunity, while it still exists for core advocacy work, has a very clear gap where settlement advice sits, and the High Court has made sure that gap is now widely understood by the profession.
And that leaves us with a final, perhaps slightly provocative thought for you to ponder. Now that the boundary of immunity around settlement advice is so much clearer, and the potential liability for lawyers giving that advice has undeniably increased, how might this influence lawyer behavior going forward?
That's a really interesting question.
Does it risk making lawyers overly cautious, perhaps even reluctant, to really push hard for settlements, especially complex ones involving future conditions or potentially risky default clauses like the one here? Could it stifle creative settlement solutions?
It's possible lawyers might become more risk-averse in the terms they recommend or agree to.
And if that happens, if lawyers become more hesitant to advise on or facilitate settlements due to fear of liability, what could that mean for the broader justice system? A system that often relies heavily on and actively encourages settlement as a primary means of resolving disputes efficiently and managing court caseloads. Does protecting clients by increasing lawyer liability for settlement advice potentially hinder the overall goal of promoting settlement?
That tension between individual accountability and systemic efficiency is certainly something the legal profession continues to grapple with in the wake of the Atwell's decision. It's a question with no easy answer.
A question indeed worth considering. Thank you for joining us on this deep dive into Atwell's v. Jackson Lalic Lawyers, a case that truly serves as both a gripping legal drama and a stark, vital cautionary tale delivered from Australia's highest court.